Hello, my name is Dr. Brett Davies. And I see one of my lawyers here has written this article on O'Mara and O'Mara, which is Supreme Court. It's just a fascinating case. So this young lass, Fatma, is a dutiful and loving, devout daughter to her mum. I'm not quite sure why the lawyer thought that, but it certainly sounded good in the story. And under some interpretation of Muslim law, which I've spoken to a few Muslim friends of mine which said it's rubbish, but it says that one man is worth two women, and that therefore accordingly there should be a double dip for the sons of the Muslim family and half for the daughters. Well, anyway, that's how Fatma's mum's will was written, and it's a suggestion that it may have been written by someone other than herself, because she seemed to be of unsound mind at the time of making it. And the doctor, even her own doctor, said that she had severe cognitive impairment and had difficulty managing her affairs. She had advanced Alzheimer's disease and dementia. In fact, it was so desperate that they actually got a thumb and stuck it on the will as a way of signing it. So I think the court has some really interesting situations here. The court did not comment on whether it's right that a woman is worth half of a man, which I thought would be quite interesting to hear what the Supreme Court judge had to say about that. But the case follows an old case of Goodfellow, which is an 1870 case. It's a Queen's Bench, it's an English authority, which says that you've got to have sound mind to make a will. You have to understand the nature of what you're signing. You have to understand the assets that you've got, and you've got to understand what the family has. Now, most people, they leave everything to the spouse leaves everything to them. So mum leaves everything to dad leaves everything to mum, and then everything goes to the children equally. That's how a lot of people do. Probably a lot of Muslim people do it as well. This woman being worth half of a man, I'd just love to see. I'd love to show this case to my wife and see what she has to say about it. So the bottom line is this: if you're drafting a will, the person has to have sound mind. They have to be of sound mind. They have to know what they're signing. They can do things like give it all to one child, less to one, and more to another. There's nothing in the law that says you have to benefit your children. You can cut your children out of the will if you want to. Whether you're Muslim or Christian or atheist, quite often that happens. And that is the decision that you make. But you need to be aware that the Supreme Court can rewrite your will in any way, shape or form. Maybe the appointer in the family trust is the executor. Well, the courts can rewrite who the executor is, and therefore all your assets in the family trust can now be lost to someone else. So be very careful. If you were drafting a will, stay close to your accountant, stay close to your financial advisor. You can draft estate planning documents on our law firm's website: three-generation testamentary trust, superannuation testamentary trust, bankruptcy trusts. And they generally will comply with Sharia law, Muslim law, and as my friends who are Muslim interpret it to be. Now, obviously, the other interesting thing in this case was that there was a precedent document that was drafted. I strongly caution you that if you are going to draft a will, draft it with a lawyer on our law firm's website. Be very careful who drafts wills. The penny dreadfuls that you can buy at a news agency or whatever, you can be very careful about how they operate. When in doubt, just pay the few dollars extra, go to our website and have the will properly drafted. You can build it yourself, see all the hints, talk to your advisor and talk to your accountant. Please blog. Please add some comments to what my lawyer has written on the case. I just found it quite interesting, and there's many other cases, but none that I've seen of this nature. A woman's worth half a man. So enjoy the case. There's citations there. You can read the case in